Hello, my name is Damion Ricketts, and my case study will be the people, which is the state of California, um, and the plaintiff, which is a hotel or innkeeper, which is also a respondent in this case, versus Julie Gavina Sachs, which is the defendant and also an appellant. The Court of Appeals of California, the verdict was handed down February 4th, 1998. And just to give you a prior history of the case, Julie Sachs appealed the decision of the Superior Court of Ventura County, which convicted her of possessing methamphetamine. Uh, Case summary: the trial court denied defendant's motion to suppress, and Julie Sachs was convicted of possessing methamphetamine. On appeal, the court held that the defendant did not have standing challenge the search of her hotel room, which was obtained by using a stolen credit card. Um, the court held that the defrauded innkeeper properly called upon the police to assist in the defendant's eviction. Uh, she did not have proper she didn't have property or possessory interest in the room sufficient enough to support her reasonable expectation of privacy. And even if she did have that right of privacy, she waived it when she voluntarily consented to the search of the hotel room and her purse. Now, the mere presence of the police officer at the door after the innkeeper legally entered was not a violation of U.S. Constitution or any amendments, and I think this is in direct reference to Amendment 4. The court held that the police officer was not required to knock or announce her presence before entering the room because the innkeeper left the room door open and the defendant consented to the officer's entry, and because the knock notice was a provision of California Penal Code 844. She did not apply to because she was a trespasser. The court affirmed the judgment. So the outcome of this case was pretty much the court affirmed the defendant's conviction for possessing methamphetamine because the defendant did not have standing to challenge the search of the hotel room. The police assisted in the police assistance in defendant's eviction was proper, and the knock notice required did not apply. Now, the facts of this case was that the appellant used a stolen credit card number to register as a guest at the Ventura Port Inn. She checked into room 301 with no luggage and spent the night. The next day, the manager, which is Cynthia, became suspicious of the manner in which a room was obtained. She called American Express, and so ensued the police being called to the premises because the card was stolen. Now, a legitimate expectation of privacy by definition means no more than a subjective expectation of not being discovered, which is according to the law. Now, in determining whether a defendant has standing to consent a search, the foundation question here is whether the defendant has a legitimate expectation of privacy in the police when the police invaded. A defendant bears the burden of showing the proof and the pertinent facts to consider when including whether the defendant has a property or possessory interest in the thing being seized or the place being searched, whether he or she has the right to exclude others from that place, whether she have exhibited subjective expectation that the place would remain free from invasion is questionable. Now, defrauding the hotel has no legitimate expectation of privacy in that room, or expectation that society on a whole is prepared to recognize as her request being reasonable. Society should not recognize an expectation of privacy in a room obtained fraudulently. The actions of the innkeeper, the police officer, and the manner in which the search was conducted was not in breach of any California laws. Defendant and the appellant forfeited her right of privacy by fraudulently using stolen property to obtain the hotel room, and then expected privacy. She consented to the search of her purse and showed she had in possession an illegal substance. The appellant has no grounds to appeal the manner of the search, notwithstanding other facts of the case, which clearly shows her in breach of several other laws. This case is quite clear cut that Miss Sachs has no grounds to appeal understanding of the manner of which a search took place, notwithstanding other charges which she faces. So it's clear cut that she would have lost this appeal.